Remember that your attorney wants to do the same evil things to the other expert that the opposing attorney will try to do to you. These lessons will help you to help your attorney do that job better with the other expert. It starts by you having read everything the other expert has ever written in this matter. He may have written an expert report, and he may also have written a rebuttal report to what you wrote. He may also have signed affidavits or declarations that affirm his support for certain technical positions in the case. In all likelihood, he will have been deposed at least once. You should have read the transcript of that deposition by now. You should now reread that deposition. Insofar as analyzing the other expert's deposition goes, you should probably have already conveyed to your attorney any evident errors or oversights or mistaken assumptions the other expert may have made. At this point, you can help by phrasing questions that your attorney can use to call attention to those mistakes and experts' technical weaknesses. Your attorney will probably have no trouble sifting through the academic background and occupational experience of the other expert to ask basic questions about them. So you do not have to phrase every single obvious question for your attorney. However, your expertise will be valuable to define technically precise questions in your industry. For example, if one part of the case really requires civil engineering knowledge, but the opposing expert is a mechanical engineer, your technically phrased questions can highlight the technical differences between those two types of engineering. This can help your attorney to better demonstrate what may turn out to be a weakness in the other expert's credentials for this particular case. Nevertheless, credentials and academic background are not necessarily the best place to find weakness in the opposing expert. You are the one who should be able to look at the other expert's technical procedures, his industry logic, the precise tests he decided to use, and the overall foundation that supports his expert opinion. You are the one who should know whether the opposing expert missed any important technical step or failed to meet an important technical standard. Experts with strong credentials do not always play the expert witness role well. They sometimes fail to do the work they should do to come to a legally defensible opinion that they can express in a court of law. The other expert's conclusion or opinion may be correct, and any one of your colleagues might generally accept it without contention. But you may only present an opinion in a court of law if it is well-founded, well-documented, complete, and accurate. The entire logical process of steps by which you came to that conclusion must be correct, it must be sufficient, and it must be defensible. You have to understand that when you take on the role of an expert witness, this is what you must do. The role is markedly different from simply being an accepted industry guru or an accepted practitioner and a specialist in your own field. An important tactic to take away from this is that if an opposing expert does not realize that he has gone about being an expert witness poorly, you have to point that out because you know how. So your attorney is better prepared to questioning him. Helping in this way does not make you a biased advocate for your side in the case. It just recognizes that you are a team player and can help your team to perform better and to produce a better result for the ultimate client that hired both the attorney and you. Your reading of the opponent expert's deposition in this careful way will help your attorney to prepare his questioning sequence better. It will also help to differentiate the other expert's methodology from your own undoubtedly more careful and professional approach to your opinions.